SJC-12429, Commonwealth v. Stephanie A. Fernandes.
Ms. Lazar, good morning.
Good morning. Ellen Lazar for the Commonwealth. This matter is before the court on the Commonwealth's appeal from an order dismissing a murder indictment against the defendant and denying an order denying reconsideration. This court should reverse these orders because the trial judge erroneously concluded that the absence of instructions to the grand jury regarding their treatment of mitigating evidence required dismissal. Before and after Commonwealth v. Walzak and before and after Commonwealth v. Grassi, the law regarding adult defendants within the grand jury has remained the same. The Commonwealth is not required in homicide cases where the suspect is an adult to instruct the grand jury in any particular way or even at all unless the jurors request instructions.
Counsel, there was some language that the judge was using in the decision in her memo in order about the cases leading before Walzak, mostly maybe in the motion to reconsider. It was where were those evidence cases or were those instruction cases? Do you know? Because it seemed to me maybe they were getting mixed up in her decision.
I know that the judge cited with regard to
the integrity of the grand jury cases,
yes,
the Mayfield cases?
That's what I was about to say. I believe that she did cite the cases regarding the impairment of the integrity of the grand jury.
So, until now, have we had anything that has said that failure to instruct would be an impairment of integrity of an adult grand jury?
No, not with regard to adult defendants. Obviously, in Walzak, the court held that where the suspect is a juvenile, the Commonwealth is required to instruct the grand jury on the elements of murder and the significance of mitigating circumstances if there is substantial evidence of mitigating circumstances or defenses.
Can you contemplate a circumstance as it relates to integrity of the grand jury where an instruction would be required? And what I have in mind is a battered women syndrome case where the Commonwealth is in possession of information about battered women syndrome, and the issue is whether or not there should be maybe an excessive force and self-defense instruction. Could that reach a point where the integrity of the grand jury could be impaired?
I mean, I suppose theoretically there could be such a case, although I really don't believe so because of the nature of the grand jury. As the court knows, the grand jury is investigatory and accusatory. And the grand jury is gathering evidence to determine whether there's probable cause to issue, in this case, an indictment for murder. The grand jury is not called upon to choose the degree of murder or to decide whether self-defense is applicable.
The grand jury is not supposed to be choosing whether it's a manslaughter indictment or murder in the second degree? That's not something that the grand jury has the ability to do?
Well, the grand jury does have the ability to do that, but
right.
these are
so
really issues.
Isn't that something that the grand jury is entitled to do, to evaluate the evidence of a case and to determine that the evidence warrants only a manslaughter indictment or an indictment of murder in the second degree?
It's certainly something that the grand jury is entitled to do, but in terms of asking whether the integrity of the grand jury is impaired if an instruction on those matters is not given, if you look at the function of the grand jury, at the time that an indictment is issued, it's unlikely that the Commonwealth would even have in its possession all of the evidence that will later come out during discovery. That is the reason why these issues are fleshed out at trial.
Well, let me stop you. What instructions were the grand jury given in this case? I don't see anything in the record to indicate anything that the jury was told with regard to legal instructions.
No, there's no evidence of instruction.
Who was the ADA who presented it before the grand jury?
Who was the ADA? I mean, not me, but I know who they were. But
Okay,
there was no.
and did the ADA provide any affidavit with regard to what instructions he or she furnished to the grand jury?
No, Your Honor, he did not. And
Do we know if the grand jury asked any questions regarding the law of the prosecutor?
no, there's no evidence.
The prosecutor had been asked questions regarding the law. Would the prosecutor not have an obligation to answer those questions?
Yes, had the prosecutor.
So how do we,
I'm confused by the answer to your first question. When you said no, meaning we don't know or it wasn't given? I couldn't understand
I'm
the
sorry.
answer.
There's no evidence, there was no evidence before the trial judge as to what, if any, instructions were given. The prosecutor did not provide an affidavit saying what instructions, if any, were given, or whether the grand jury had asked for any instructions. The judge assumed, for purposes of her decision, that no instructions were given. And of course, at the time of this indictment, and even now, there's no requirement that any instructions be given.
so let me step back. So you agree there is an obligation, if the jury asks questions that regarding the law, for the prosecutor to answer the question.
Yes,
And we do not know whether the grand jury asked any questions here because the prosecutor furnished no evidence with regard to it.
that's correct.
Now, so basically, all that we know is that the grand jury was given an indictment which said that the defendant did assault and beat Mr. Wagner, resulting in his death.
Yes.
That's all that the grand jury, to our knowledge, was given.
Well, no, the grand jury heard a year's worth of evidence.
Right, I understand
before
that. But what are
returning that
they,
indictment.
if the question was, I guess the next question is, let me ask you this. If you had not furnished all of the evidence of mitigation that you did, and I think there's no question, Mr. Ettenberg, I think, agrees that you fulfilled your obligation to furnish mitigating evidence to the grand jury, but if the grand jury is simply asked, did she assault and beat him, causing his death, why bother? Because, of course, she assaulted and beat him, causing his death. That didn't go to any of the issues that you presented with regard to mitigation.
I believe that the evidence that was put in was not only for purposes of showing mitigation or even principally for that purpose. It was to give the grand jury a full picture of this 5-year relationship between these two people, which clearly had hostility on both sides, dysfunction on both sides. The defendant, in her interview with the police that was several hours long, at some point, approximately 2 hours into the interview, for the first time claims that there was an altercation and essentially says that, not in these words, but that she was acting in self-defense or acting to protect herself. So part of the evidence was, in essence, to respond to that, to give a full picture of the events surrounding that night and surrounding the entire relationship.
And if the grand jury had understood that evidence to indicate either that she was acting in self-defense or that there was reasonable provocation or sudden combat which caused his death, if that was the jury's finding, how were they to know that had consequence in terms of what indictment they should return, when all that they were told was, the only question they were asked is, did she assault and beat him, causing his death?
It has never been required that the grand jury be told
I
how they
understand we
should
haven't
treat.
required it, but
Yes.
try my question. How is the grand jury to understand if they reached that factual determination? How are they to know what to do when all that they are given is an indictment asking what was essentially not really even the defense is disputing, whether she assaulted and beat him, causing his death?
In the same way that the grand jurors are expected to treat or understand any other evidence that's presented to them in any other kind of case. I mean, there's no reason that a homicide should be treated differently than any other case. There are cases where a defendant might raise a certain defense, like the so-called castle defense, or or consent in the case of an indecent assault and battery.
Can we put this discussion perhaps in a broader context of the role of the grand jury and what its purpose is and the historical function of it and the difference between a grand jury and a trial?
Yes, Your Honor, and as I had started to say earlier, the function of the grand jury is to be investigatory and accusatory, and it's guided in large part by the grand jurors themselves, who, if they want to hear certain other evidence, will ask for it. If they want to hear certain instructions, will ask for it. Perhaps if they don't want to hear certain instructions because they say that they're not interested in hearing it, will indicate that. The prosecutor is there, obviously, in some sense, to present the evidence, but also as an aid to the grand jury.
Counsel,
And I
when,
think
when the grand jury is oriented, are they told that they can request legal instructions? I mean, how would they know that they can ask for more information?
Yes, Your Honor. I believe that when the grand jury first sits, they are given introductory remarks by a judge.
Right.
That includes information about the role of the prosecutor, that they can ask for legal instructions, that they can ask for certain evidence to be presented if that's possible. So they are told that at the outset.
They're told they can ask the court as well.
Yes, yes, they
But
are.
I mean, isn't there any obligation on the part of, when a motion like this is brought, and the prosecutor has not provided a transcript of any legal instructions, is there not an obligation on the part of the prosecutor to furnish an affidavit saying, here is what I told them, and whether or not they asked any questions? Or is we supposed to just guess?
Your Honor, this case was indicted long before Commonwealth versus Grassi was issued, requiring that the instructions be recorded. To ask a prosecutor to put in an affidavit sworn under pains of and penalties of perjury, this is exactly what I told them over a year-long presentation to 4 different sitting grand juries, I think was something that, frankly, I would not have asked the prosecutor to do because—
You wouldn't ask a prosecutor to say, did you give them any instructions about self-defense in a case where you presented evidence over the course of 4 grand juries? I mean, this was, I guess let me step back. There were 4 grand juries in this case. Were the first 3 invited to deliberate?
I don't believe so. I think that the minutes from the first 3 each time were transmitted to the subsequent grand jury until the 4th one issued the indictment.
So, and you,
As far as I
you
know.
don't think it's appropriate to ask a prosecutor, even if the prosecutor remembers?
No, Your Honor, because for purposes of this case, again, the judge assumed that there were no instructions, and the Commonwealth did not dispute that, because the point is the Commonwealth was not required to give any instructions.
Did you finish your answer regarding the traditional role of the grand jury?
Well, if I can just take a step back and talk about Walzak, which is where all of this began. Judge Kenton Walker's decision to extend Walzak to the case of an adult defendant really ignores the principles that were animating Justice Lank's concurrence, limiting it to the case of juveniles, because she was concerned, and ultimately it's the opinion of the court, that once a juvenile is indicted for murder, that case goes to the Superior Court, and the juvenile loses all of the protections or benefits of being proceeded against in the juvenile court. That is not the case with an adult defendant who is indicted based upon probable cause and who can raise all of these issues and many more at trial. Anything that the defendant here says should have been brought before the grand jury, whether it's a defense or mitigating circumstances or certain instructions, that could have been brought to the attention of a petty jury a long time ago. And in the cases holding that the Commonwealth is not required to instruct the grand jury, it's recognized that a different rule would add a whole host of complexity and delay, really serving no significant purpose. And this case is a perfect example of that. The victim was killed 4.5 years ago. The case was essentially ready for trial when the defendant moved to dismiss more than 2 years ago. We are now here more than 2 years later, still arguing about whether or how the grand jury should have been instructed when all of those issues could have been brought to the attention of a petty jury who could have resolved those issues when they had the full information available to both parties in front of them. This court has recognized repeatedly that the Commonwealth is not required to present evidence of defenses or to disprove those defenses in the grand jury. But it's unrealistic to believe—
Wait, but you have an obligation to present exculpatory evidence.
exculpatory evidence that rises to a certain level,
Right.
not all exculpatory evidence.
But you did here. I mean, there isn't, the Commonwealth has an obligation to provide exculpatory evidence, including evidence of mitigation.
If it rises to a certain level where its absence might impair the integrity of the grand jury, which here I actually don't think the evidence presented even rose to that level. So I think the Commonwealth presented more than it was really required
And
to.
counsel, to what extent is the evidence tested before the grand jury so that they can assess the credibility of it? The witnesses are examined by the prosecutor, and the grand jury can examine them. But if there's evidence of a defense or evidence of mitigation or anything else, that would come in how?
Yes, so the credibility of that is not tested. The evidence that came in here mostly came in through the statement of the defendant, which she gave to police, and the Commonwealth did present that entire statement, including her denials or her explanations of what had happened.
Can I ask one more question, and that's about the best, have you seen the best practices report?
Yes, I have.
And to what extent is what happened in this case consistent with those practices, and to what extent are the best practices consistent with our previous case law?
I think that what happened here is consistent with those practices to the extent that they just encourage prosecutors to use their discretion to give instructions in certain cases, to consider presenting this evidence, and if the evidence is presented, to consider instructing on it. I don't think that that really changes anything that's required by the cases.
But didn't they say the best practice was to give the mitigating instructions? But that separation of powers requires that they not be compelled by the court. So we're expecting prosecutors to give us a self-defense instruction in a self-defense case, give the mitigating instructions in a case in which there's mitigating evidence, but not require them because it's a constitutional separation of powers. But it didn't live up to the best practices in this case, right? We can't tell whether there's a self-defense instruction given, right? And that clearly is a required instruction here, right? Not in court, at trial, not at this level.
If the exact same evidence that came into the grand jury came in at trial, then yes, I expect that the judge would give a self-defense instruction.
Well, not expect, he would be required to, right?
Yes,
So how, in response to Justice Cypher's question then, it isn't, the best practices weren't followed here, at least, that report obviously happens after this case, but they're not followed here, right?
No, I don't agree, Your Honor, because the best practices simply encourage prosecutors to use their discretion to do this. And I think that that is what happened here.
So how would that not be advisable in this context, given the amount of self-defense evidence that's before us?
Well, Your Honor, whether it's advisable is really not the standard. The judge found that the integrity of the grand jury was impaired by the absence of instructions, and the Commonwealth disputes that. There's been no case that ever said that the absence of instructions impairs the integrity of the grand jury. There's been no case that ever requires instruction.
I know what the case law says, but I guess my question is, if you're saying, if that report only means that it's totally discretionary, that it's a best practice not to give it even when it should be given, then I'm lost about what that report means.
I don't think it says that
So
it's...
your view of the report is it's totally their call, and best practices meaning is just pure discretion.
I think that in the end, yes, that's what it says. Those are the words that it explicitly uses. It encourages prosecutors to use their discretion.
Well, it doesn't encourage, it says the best practice is to do that, right? And then we're, right?
I think it says that the best practice is to consider giving the instructions in their discretion. And so I don't think that that changes the law in any way, and I don't think that what happened here violates that.
If I could ask one more question, Chief? Where does the line cross when the absence to give an instruction on mitigating circumstances would lead to the impairment of the grand jury? I think that's really the issue here, is because the integrity of the grand jury is the key, and that's when a prosecution violates it, and whatever Article 30 requirements there are or aren't. Where are we supposed to draw the line between the failure to give instructions and impairment such that the integrity is diminished?
I don't think that it
Okay.
would ever be impaired by the failure to give this instruction. I mean, the evidence is presented to the grand jury. The grand
And-
jury is permitted.
In this case, in any case.
I mean, I suppose, I don't know if theoretically someone could present me with a case where I would say something different, but certainly in this case, in any case that I can think of, in any of the cases that have been cited, the evidence is presented to the grand jury in any kind of case, not just a homicide case, that the grand jury is allowed to consider, the grand jury is allowed to determine what to credit and to not credit. And then they're permitted to issue an indictment if it's based on probable cause. Judge Kenton Walker here explicitly found that this indictment was supported by probable cause. And again, the case could have been tried 10 times over by now, rather than spending 2 years litigating an issue that could have been raised at trial based upon all the discovery, all of the evidence, when both sides had all of the information before them, rather than trying to turn the grand jury into essentially a mini trial. If the court were to decide that, despite that the court has said that the Commonwealth is not required to present evidence of defenses or then to disprove them, if the court were to decide that the Commonwealth is required to instruct on the treatment of mitigating circumstances or defenses, it's unrealistic to believe that the Commonwealth will not then be obligated to disprove.
But I
The
don't think
mitigating
that, I don't think that's really Justice Gaziano's question. I mean, going back to my initial hypothetical, what the issue is Mayfield. And let's say there's just years of abuse, and it's uncontroverted that the perpetrator suffers from battered women's syndrome, and that the Commonwealth is entirely in possession of that information, and that the alleged victim boyfriend initiated the violence. And the evidence, it's palpable that this was, even if the evidence is credited completely, this is a case where self-defense is absolutely at play. Is there a point? Is there a point at which time not instructing them rises to the level of integrity of the grand jury being impaired? That's what Justice Gaziano was asking, and that's what I was asking initially. Could there be that point?
I don't believe so, as long as the indictment was still supported by probable cause. If the grand jury hears all of that evidence and still determines, based upon probable cause, that they believe that that suspect committed that crime, then I believe that all of those issues that you're raising are issues that are really meant to be raised at a trial. It's not the purpose of the grand jury to sort that out and choose the degree of murder that the defendant is ultimately convicted of. Obviously, the grand jury chooses what to charge the person with, but I think that based on the historical purpose of the grand jury, as long as that indictment is supported by probable cause, that's an issue.
So a defendant and a victim get into a fight, and the victim has the upper hand, beats the defendant to within an inch of his life. As he's about to stab him, the defendant grabs the knife and stabs the person who initiated the contact. Clearly self-defense. The guy just in desperation, stabbed him. Police officer testifies that I came to the scene, the decedent had a stab wound in his chest and an indictment issues. No self-defense instruction.
Well, I think that's different, Your Honor, because I think
Well,
then...
let me ask you my
Oh,
question.
sorry.
All right? No self-defense instruction to the grand jury. Just proceeds as a vanilla, one stab wound. Has the integrity of the grand jury been impaired?
Then I think there's a good argument that it has, but not because of the absence of the instruction, but because of the absence of the evidence. I mean, we do have the cases that say that if you essentially distort the evidence in front of the grand jury, you give half the picture, you give half the
Like
statement.
an Odell issue?
Right, so that, I think, you're impairing the integrity of the grand jury, not because of not giving the instruction, but because of the evidence.
You would say under Odell, by giving half the story or a very small slice of the story, the integrity is impaired. What you are not saying, though, is that by not giving the legal context of that, there's no impairment.
Yes.
Right.
So in the example that Justice Gaziano gave, if the prosecutor had offered the entirety of the account, you would say that there's no obligation to tell the jury that self-defense is an absolute defense, the grand jury.
Yes, I would say that.
Even though that's, even Justice Spina and Walzak sort of cabined off self-defense a little bit, right? That pure, I mean, I understand, he draws a distinction between charges that are going to lower the, murder to manslaughter, but self-defense is an acquittal. So you shouldn't even be proceeding, right? I mean, isn't self-defense a little different? In Justice Gaziano's hypothetical, it looks like a pure acquittal, but the jury doesn't even understand that.
I think to some extent, all of these factual scenarios show that it's almost an impossible line to draw. Well, what about this case with these facts and this case with these facts? I mean, that is why these are issues that are fleshed out in front of a trial
But Justice
jury.
Spina in his dissent in Walzak does sort of focus on the difference between self-defense and mitigation, doesn't he? I mean, he's pointing out that the majority is relying on pure self-defense cases to justify mitigating circumstances instructions. So there is a difference, and Justice Gaziano's hypothetical sort of highlights that. So even in that context, not giving an instruction that would explain to the jury that that's a not guilty, you shouldn't be proceeding.
But again, if you look at the case in terms of the purpose of the grand jury and the stage of the proceedings, so this is what we know right now. This is the course of events that we're describing to the grand jury right now. Once the indictment issues and discovery is done and the investigation continues, we don't know if there's more information that could be elicited on either
You
side.
think a grand juror who walks away after grand jury service would shake his or her head knowing that they returned a murder indictment in that scenario that I just gave you? And feel that they were sold a bill of goods by the failure to instruct?
Not if they were presented with all of the evidence.
But they
If
don't
the grand
understand.
jury-
They don't understand what the evidence means. The chief's point. They don't get. They think that could still be a crime. I mean, even if you
That they had a manslaughter opportunity, they had a manslaughter option, they had a not guilty or a no bill option, and they still returned a murder indictment because they think, he stabbed him.
But every day of the week, jurors are instructed at trials that an indictment is not evidence of guilt. An indictment is only an initiation of proceedings against the defendant. That is the beginning of the process, it's not the end. And while I don't deny that being charged with a lesser crime does have some significance, it's not the same as the
You keep
concerns.
ignoring the harder part. It's not that it's a lesser crime, it's not a crime. That one option is it's not a crime, right? I mean, I get you completely when you're talking about manslaughter versus, first or second degree murder. It gets trickier in a pure self-defense case where, doesn't it? I mean, where the jury isn't even told that can lead to an acquittal. I'm not saying it's required, But you don't seem to like the best practices approach either. You're just saying it's totally the prosecution's call.
Well, again, I don't dispute the best practices. I just read them as saying that it's the prosecutor's call whether to
But
use his
how
or
is a
her
best
discretion.
practice, I don't know, I'm repeating myself, but a best practice that is whatever the prosecutor decides to do can't be the best practice. There are better practices and less good practices, aren't there?
In the best practices, as I read them, they encourage prosecutors to consider doing this and then exercise their discretion as to whether or not to do it. But there's no requirement to do it. There never has been, and at this point, there still is not.
Okay, thank you.
Thank you.
Mr. Edinburgh, we appreciate your patience.
It's my pleasure. My name is Peter Edinburgh. I represent Stephanie Fernandes. May it please the court. Have you ever had an aha moment? I know you can't see what's on my phone, but this was my aha moment. In August of 2015, I made a note. The grand jury heard this case over a year, and they issued their indictments in June of 2015. I got them probably in July of 2015, and I made a note to myself in August of 2015, motion for grand jury instructions. I made that up. I don't even know if there is such a thing, but there was something that wasn't right with this.
Well, I think, counsel, there may be such a thing, or you could have made the motion in any event. Did you make the motion?
I did not make the motion.
Okay, so what's the aha?
The aha is something wasn't right. Something just
All right, well,
wasn't right.
okay, maybe not, but can you tell me the difference between, in the best practices, they talk about the prosecutor should instruct if it is in the interest of justice, but the case law has said in appropriate circumstances. Is there a difference?
I think this is the appropriate circumstances.
Is there a difference between those two things?
I don't think so.
Okay, and do you think the best practices are consistent with the case law that we've had up to date?
I think that the best practices give greater guidance than the case law. I think that they talk about specific instances where these best practices come into play, and that's kind of an extension of what the cases have said.
And can you tell me whether Walzak, in its reasoning, I don't recall, whether it was based in any part on integrity or impairment of the grand jury, or was it purely based on the status of a juvenile?
I think it was just based on the status of the juvenile.
And what do you say to the argument that if we open this door, grand jury process or the litigation process about the grand jury situation after the grand jury comes back with an indictment would take forever?
I don't think it would take forever. I don't think
For
it would.
4 years, maybe.
Well, I think this case is a little bit different, and it's got a long history. I mean, just the fact that there were 4 separate grand juries that heard this case and stretched it over a year made this case a long case. I think the answer is, where does this go? Are we opening a Pandora's box? I don't think that we are opening a Pandora's box. I think that there are cases, and I suggest that this is a fantastic set of cases, set of issues, set of facts here that give the court the line that Justice Graziano has talked about. Where is the line? I mean, give me a better set of facts that show mitigation and self-defense.
Are you speaking for every defense attorney in the Commonwealth when you say, I won't come back to you and ask for this in every crime?
No, I'm not. I thought about that as well.
So we have a rape case, and there's a so-called date rape, and there's no consent instruction. Wouldn't next year a defense attorney come in front of us and say, you know what, this is unfair, they were sold a bill of goods, why wasn't there a consent instruction?
Well, I think I thought about that as well. And, should an instruction like that be given in a lesser crime? I mean, I was thinking that assault and battery with a dangerous weapon to assault with a dangerous weapon. Should there be given these lesser crime instructions? And the shorter answer is, from a defense lawyer's point of view, absolutely. I would love to see that. But Walzak talks about murder. Grassi talks about murder. My case talks about murder. So I'm addressing the issue of what should be done in a case where you've been given significant evidence of mitigation, self-defense, and not told the grand jury what all of that means. This is the case that should extend Walzak.
Where's the line between impairment of the grand jury, the integrity of the grand jury, which warrants an instruction, and that which doesn't? How are we supposed to draw that magical
Well,
line?
I think,
I mean, the Commonwealth has an easy answer for that. There is none. What's your answer?
I don't disagree with that. I think the point is this: where is the line? I think it's really on a case-by-case basis. And as the best practices talk about, and as prosecutor here talks about, it's the prosecutor's call. But I think that the case here clearly describes a set of facts where instruction should be given, or there should be some evidence of some questions. We don't even know whether questions were asked.
If we gave you the pen, how would you write that rule?
How would I write it?
Yeah, how would you articulate that line?
I would like the rule to say that if there is evidence presented to a grand jury that indicates that there can be a lesser crime or some instruction, they should be given.
Why should the grand jury be deciding?
He's going to finish. He's going to finish his,
sorry, go
his
ahead.
paragraph. Go on.
Thank you. That the grand jury should be given an instruction on whether or not a lesser crime should be issued by the grand jury. Justice Gantz.
No, but then why should grand juries be deciding lesser crimes? That I don't get.
Well,
I understand why they should decide possibly self-defense and acquittal, but they shouldn't. Why are we having grand juries do that level of sorting out?
Well, I'm going to step back a little bit, and I think what would be best would be a situation where, such as this, where there is evidence of a factor, and in this case the factor is mitigation or self-defense. If there is evidence of that, I think then the instruction or an instruction should be given.
Then basically we're turning the grand jury into the trial. That to me, that doesn't. I don't see why that. That's certainly not supported by Walzak, because Walzak's a juvenile. Nor is it supported by the best practices recommendations. That's just a gigantic change.
Oh, I'm not disagreeing that giving those types of instructions in every case is difficult.
Well, you just said if there's any evidence of this, we should give
I would love to see that. That's what I would like to see. I would like to see, and as Justice Gantz said in Walzak, any trial lawyer would love to try a case from a manslaughter rather than a first-degree murder. So from my point of view, from a defense lawyer's point of view, would I rather...
That's what you get to do at trial. The grand jury decides whether there's a crime has been...
And just Judge Kenton Walker here said there was probable cause for murder. No doubt about that. But then again, we come to
Well, if there's probable cause for murder, and if a jury even, or a grand jury is entitled to, and come back with the highest defense available, what's the issue?
Well, the issue is that when the prosecution puts in substantial evidence of mitigation and just throws it out there and doesn't say what it means, that's impairment.
Could it not come back not guilty in those, not guilty, but no bill?
Sure.
All right, and so now let's take the Article 30 considerations, because you agree there are some here. Where is the line within Article 30 in terms of when the judiciary may enter that and tell the prosecutor how to handle their grand jury?
Well, it's hard to give a line. I don't think that that's a surprise. I think it is hard to come up with a bright line, and I think it's a prosecutor's call. I think that it's a judge's call on whether or not that line has been met or that line has been crossed. So I can't give you a specific answer of where is the line and how does that fit into Rule 30. I think what the issue here is that this is a murder case. Walzak was a murder case, and Walzak and then Grassi says, we're going to leave for another day if there are facts that warrant it to extend Walzak. And I suggest that these are the set of facts. The prosecutor in this case didn't just put in exculpatory evidence. They put in the good, the bad, and the ugly. They just threw everything in there. They threw it in like a stew, but they never told the grand jurors what kind of meat they were using.
What if they had not put it in?
I'm sorry?
What if they had not put it in?
Then it would have been, I think, an Odell motion would have most likely been the circumstances. In this case, I filed a motion to dismiss. I said the grand jury should have been instructed, and Judge Kenton Walker agreed with that.
So what's our standard of review on that, if it's a motion to dismiss? Are we looking at an error of law here?
Yes. And I think that to not do it would have been an error of law if the judge had not done that. So I think...
Haven't we already established the standard, the Article 30 standard, as impairment of the integrity of the grand jury? Isn't that the standard?
Yes, I think that it is.
So the issue here is whether or not the failure of instructions impaired the integrity of the grand jury.
And I suggest that it did. I suggest that the failure to give the instructions did impair the grand jury.
And then the issue is, we know that with regard to the failure to furnish exculpatory evidence, we figured that out with an Odell motion. The question you're being asked is how do we figure that out with regard to a motion that says the evidence was adequately presented, but the law was not? How do we determine when that reaches the level of impairment of the integrity of the grand jury?
And I think what you have here in this case is a clear set of facts that show mitigation, self-defense, and there's nothing about what that means. And I think that if you are presented again with a clear set of facts, and there may well be lawyers along the line in the future who are going to say my set of facts is just as good as the facts in Fernandes. And they may well, and you may be arguing this issue for a long time. But I think that when you look at this particular set of facts, this set of facts creates the obligation to instruct the grand jury.
Sort of a combination. To get to Mayfield, to get to the integrity of the grand jury, I think what you're saying is that you have to, the evidence that's presented, it's actually a distortion of the evidence, to use the words from Odell, not to explain the law as to what those facts mean, and that it has to rise to a certain level. It's almost like a synergistic effect of Mayfield and Odell.
I agree. I mean, I think it has to rise to a certain level, and I think this set of facts rises to that
But it's
level.
not the facts, it's the instruction, the lack of instruction. And so the question is, can we transfer, as Justice Gaziano put it, the legal context issue to the fact issue that we've been using all these years? We've said, yes, with these facts, it's for the grand jury, but the decision on the law, that's a different kind of question, isn't it?
Well, it is, but I think that you can't lose sight of the facts. You can't lose sight of the facts and then not apply the law. And I think what happened here is the prosecutor presented the facts, but then ignored the law.
What if the
Don't
prosecutor
know what
gave...
the prosecutor did.
Yeah.
Well, I think the silence of no affidavit and no explanation that instructions were given gives you the answer.
What if the prosecutor did instruct and gave you a copy of the instructions, and the instructions had some errors in them? What would happen?
Well, then I'd have to come back to the trial judge or the judge sitting in some session, file a motion to dismiss, saying that the instructions were wrong.
It sounds like at the very least you're saying that murder should be where we definitely give instruction, or we have instructions given.
Well, that seems, I'm sorry, I didn't mean to
Well,
interrupt.
no. My question is, are you saying that, or are you agreeing with Justice Kafker that it should be as only in the situation of self-defense?
And I guess I come back to my answer that I gave then, which is from a defense lawyer's point of view, I'd love to have them.
No, I understand your point of view. I'm trying to understand
And
what we should be doing. what you
I'm
think
really
we should
just
be
dealing,
doing.
I'm sorry, I'm just dealing with a murder case right now. And I think that's where we ought to start, because this case presents those facts where the instructions should be given. And so this is the appropriate case. It is a murder case.
And is it true that one of the reasons you say because it's a murder is because of the consequences to the defendant, the life sentence?
Absolutely.
Well, isn't that true with many sex cases
It sure is.
now?
It sure is.
Or other armed robberies or many things?
It sure is. And I'm saying, I'd love to have those
I know you
instructions.
want
And do I want you to do that? Yes, I would love you to come back and say that instructions should be given in those types of cases. But I can't. I mean, this is
And can I-
an extension of Walzak.
Can I push you a little bit? Because, so we have to give the instruction at trial in the light most favorable to the defendant. If any reading of the evidence before the grand jury justifies mitigating instructions or self-defense instructions, they have to be given in a murder case. I'm just, because Justice Gaziano's hypothetical posed this sort of compelling set of facts that, almost directed verdict set of facts. So I'm just trying to understand, are you saying that if the same standard applies at trial to grand jury, meaning obviously you don't have a defense presentation, but
Right.
Is that your standard? If any reading of the evidence would support an instruction at trial, it's an impairment of the integrity of the grand jury process not to give the instruction? I'm just trying to get a sense.
No, I don't think that,
So articulate better that part, because
I
you
don't-
keep saying
I-
these facts, and I just don't know what that means a little bit.
I don't think that would be necessary, because it isn't a complete picture. There isn't a defense, there isn't the opportunity to make that whole picture.
Right.
In this particular case, even without a defense, even without anything, that picture has been presented. So I think that this is a little bit
But
different.
what happens when the police go to the scene and they find in the defendant's house a crack pipe and other indicia that the person had a drug dependency? And then the defense attorney says, aha, my person was impaired, you didn't present that to the grand jury. All those cases we have where it's on the line as to whether a judge instructs, right, on intoxication or some type of mitigation. Don't you think that every defense attorney, if we were to say you were right, would then raise the motion and say there was a failure to instruct on intoxication, there was a failure to instruct because the person was hospitalized when they were 12, there was a failure to instruct for all these things?
There's no question that you could go down a rabbit hole, and we could be stuck.
Are you going to promise on behalf of all defense attorneys not to do that again?
Not if I want to live.
All right.
Well, wouldn't the defense attorney have a ethical responsibility to file that type of
Oh,
motion?
absolutely.
So isn't that the slippery slope problem?
That is the slippery slope problem. There's no question about it. But again, I want to deal only with a murder case, because that's what I'm
No,
doing.
I'm talking about all the evidence that we see every day on
Right.
Friday for failure to instruct for intoxication, failure to instruct for diminished capacity. All of those cases. We have a prosecutor who's gathering evidence of a crime, doesn't have responsibility to seek out defenses.
Well,
So it's basically whatever happens to fall into the prosecutor's lap has to be presented to the grand jury and then instructed upon?
I think what has to be looked at are the particular set of facts and whether or not those set of facts rise to a certain level. I think that in this case, and again, I have to come back to this case, the facts of this case rise it to that level where the instruction should be given.
So we figured this out like we did Odell.
Yes. I think you have to. I think that you have to look at it from whether or not those set of facts make the prosecutor basically pause and say, wait a minute, maybe I should instruct on this, because there is substantial evidence of that issue.
But counsel, isn't it more, Article 30 is not just putting all the right evidence in front of the grand jury, it also goes to the prosecutor's decision as to how to charge. So if the prosecutor, at that point, aren't we getting into their decisional, discretionary authority under Article 30? As to how to charge how to charge the indictment, how to charge the defendant, which crimes do I pick?
The short answer is yes. And it is a call of the prosecutor. The best practices say it's the call of the prosecutor. But again, you have to look at the set of facts and how high do those facts go? How significant are those facts? And there may well be cases where it slips through the cracks and the instructions weren't given even with the instructions not being given or being given. And to go back to what Justice Kafka is saying, where's that line and shouldn't we apply it to all the cases? I think that's a prosecutor's call. They have to look at it and see what are the set of facts and what does it rise to, and in each individual case. And every day, as Justice Gaziano said, every day we hear these types of cases and everybody comes in and argues them. Well, that's what you're there for, and that's what we're supposed to present to you. And you're going to make a decision. Is it going to apply to an assault and battery with a dangerous weapon case, or is it going to apply only to murder cases?
When you speak about Article 30, the last I looked, the grand jury determines who's indicted.
Correct.
The prosecutor decides what to present to the grand jury, and even what to ask the grand jury to do, but the prosecutor does not decide what the grand jury does.
That's absolutely correct. But the grand jury has to know what to do
So
and what choices they
how is it
have.
how is to say that how is a rule that says that the impairment of the integrity of the grand jury encroaches on Rule 30? I don't understand why. Is it the prerogative of the prosecutor to impair the integrity of the grand jury? We've said no in Mayfield.
I would certainly hope not. I don't think that's the case. I think that again, it comes back, I think, to a case-by-case basis, and the prosecutors that present cases to the grand jury are generally very well experienced, and they know, hopefully, what the law is and what they should be doing with that. So I think that you have to look at the facts, and do those facts create the issue where you should give an instruction?
And just to be clear, you agree, I believe, that there was no Mayfield violation here in terms of what the prosecutor presented to the grand jury?
Oh, no. The prosecutor threw everything in. I don't have any qualms with what the prosecutor did. They just threw it out there and left it. And if I could just finish, to paraphrase Justice Gantz in Walzak, where he said, this, like Walzak, is one of those rare cases where the evidence of reasonable provocation, sudden combat, and self-defense is so strong that the integrity of the grand jury was impaired by an absence of pertinent instructions. And I think that's what this is all about, and I'm asking you to maintain the decision by Judge Kenton Walker.
All right, thank you.
Thank you.